Hello, students. As promised, this is the review presentation for assignment 3.1. I felt like it was very important for me to create this presentation because after grading the assignments, I saw that there were some errors that were being made repeatedly by some of you, and some of you also had some individual questions as to why you were graded in the manner in which you were, and I felt as though your questions would be better answered in this presentation as opposed to me responding via email. Now, before we get started, I just want to say that some of you disagreed with or had questions about the way that you were graded, and I noticed that a lot of you would preface your discourse with Attorney Woods, I don't want to be rude, but I just have this question and I have that question. I just want to say that you don't have to preface any type of substantive challenge with, I don't want to be rude. I don't consider it being rude at all. I welcome all challenges that you may have. Any substantive challenge or any substantive question that you may have, or any type of disagreement that you may have with anything that I've done, please voice it. Please share it with me. That is something that I welcome in this course because it lets me know that not only are you thinking outside of the box, but you are able to confidently stand by the decision that you make. So again, please, I welcome any questions, any challenges that you may have. It's not a matter of you being rude or anything like that. I just want to let you know that I welcome those types of things. So moving right along, the first thing that I want to discuss in this presentation is the difference between being charged with a crime and being convicted of a crime. And the reason why I am addressing this is because one of the students brought this up to me in an email, and I just wanted to be clear that someone can be charged with a crime and then end up not being convicted of that crime. Okay, and the reason that is possible is because the standards of proof are different. To charge someone with a crime, the police must first have probable cause to make an arrest. Probable cause is a reasonable belief that a person has committed or will commit a crime. So for probable cause to exist, a police officer must have sufficient knowledge of facts to warrant a belief that a suspect is committing or has committed a crime. The belief must be based on factual evidence and not just on suspicion. So probable cause is the standard to charge someone with a crime, and by that we mean arrest someone for committing a crime. Okay? Now, to convict someone of a crime, the standard of proof is higher than probable cause. The standard of proof to convict someone is beyond a reasonable doubt. And beyond a reasonable doubt means that there's no other logical explanation. Okay, no other logical explanation can be derived from the facts except that the defendant committed the crime, thereby overcoming the presumption that a person is innocent until proven guilty. So, with that being said, you now know that there are two different types of standards of proof. To charge someone, to make an arrest, there must be probable cause, and to convict someone of a crime, the standard of proof is beyond a reasonable doubt. So the question that was ultimately asked in assignment 3.1 was, with which crimes could the individuals be charged? So, with that question, we know that the standard of proof that we're going to be working with is going to be probable cause and not beyond a reasonable doubt. So now I would like to provide you all with some context as to how criminal proceedings, take place in the Virgin Islands. Okay, so first we have a person commits a crime. Okay, and after this crime is committed, generally the police officer makes an arrest. And we now know that in order for the police officer to make that arrest, the officer has to have probable cause to make that arrest, okay? After that arrest is made, the officer will then prepare what is called a probable cause facts sheet, which will contain all the facts that led to the arrest. So, for example, if we consider Bob is the individual from the assignment who set the house on fire, okay? The question here is, what will his probable cause fact sheet say? Well, the probable cause fact sheet will talk about how a fire was started at the neighbor's house, which resulted in the house being burnt down. An individual who was in the home while it was being set on fire was able to escape the home from a window. I believe the fact pattern said that he escaped through a window. And then the probable cause fact sheet will also indicate that I think 2 or 3 days after the fire, law enforcement officers went back to the scene. They were able to procure the surveillance footage from Bob's home, which showed Bob setting the house on fire. Okay? This is what will be in the probable cause fact sheet, because this fact sheet will support the officer's act of arresting Bob. The facts in the probable cause fact sheet are what is necessary to prove that the officer had probable cause to make the arrest in the first place. After the arrest has been made, the defendant, who he's now the defendant because he's been arrested of this crime, the defendant then proceeds to a hearing that is called advice of rights. Another term for advice of rights is a probable cause hearing. Now, what that is the officer decided that he had enough probable cause to arrest this individual for setting this house on fire. Now, at advice of rights, we have to present this to the judge, and then the judge will ultimately decide whether or not there is enough probable cause for us to proceed with formally charging this individual, Bob, with first-degree arson. What is the judge going to use as his basis for determining whether or not there was probable cause? The judge is going to rely on the probable cause fact sheet that was prepared by the officer to determine whether or not there's probable cause to proceed. So with that being said, there could be an instance where the officer feels as though there was enough probable cause to arrest the individual, but then when we get to advice of rights, the judge could very well decide there's not enough probable cause to proceed, so I am going to throw this out. And if that happens, then the defendant is free to go. So it is very important to establish that there was enough probable cause, because if there was not, then the arrest goes out the window, the charge goes out the window, and the defendant is free to leave. Okay? So with that being said, let us move on to Bob, because Bob is one of the individuals who you were asked to determine what crimes he could be charged with. So many of you were correct in noting that Bob could be charged with first-degree arson and he could be charged with conspiracy. However, some of you indicated that you believed that Bob could also be charged with attempted murder and that Bob could also be charged as an accomplice. Now, the title of this exercise was Elements of a Crime. So your job was to determine whether or not the elements of the crime were satisfied, so much so that we could proceed with charging this individual with the specific crime. Okay? So when I say elements of a crime, what I mean is what has to happen, what has to occur in order for us to charge this person with arson in the first degree. Now, according to the code, the Virgin Islands Code, it says a person is guilty of arson in the first degree when, with intent to destroy or damage a building, or while in the commission of any felony, he starts a fire or causes an explosion. So those are the elements. You have to have the intent to destroy or damage a building, or while in the commission of any felony, he starts a fire or causes an explosion. Those are the elements for arson in the first degree. So now you have to ask yourself, were these elements satisfied based on the facts that were provided in the problem? Based on the facts that were provided in the problem, can we charge Bob with arson in the first degree? Yes. He had the intent to destroy or damage his neighbor's home, and this is evidenced in the tumultuous relationship that he had with his neighbors. That relationship was outlined in the problem. So we know that Bob and his neighbors had problems. We know that when the neighbors were leaving town to get away from the storm, they had an altercation. So yes, Bob had the intent to destroy or damage the home. But is that all that we can use to evidence his intent? No. Bob had a conversation with his wife about burning down his neighbor's home. They discussed it, obviously, based on the facts that were presented to you in the problem. His wife, with whom he conspired, went and purchased the gasoline. So these are the things that I wanted you to highlight in your response to show that Bob had the intent to destroy or damage a building. Now, did he start a fire or cause an explosion? Yes, he did. He caused a fire. The facts indicated that he doused the outside of the house with gasoline. He lit a match, set the house on fire, and then ran back to his home. Those facts satisfy what is required here for arson in the first degree. So we have the intent, and we have that he started a fire. Now, here it says, while in the commission of any felony. We really don't need that part because it's an or. So, or means you can have that aspect or you cannot. So, we don't even need to examine that. If it said and while in the commission of any felony, it would be a different story. But since it says or, we don't necessarily need that. So this is a perfect example of why Bob can be charged with arson in the first degree, because the elements were satisfied. This is the type of analysis that I would expect in a question like what was presented to you in the problem, which ultimately is asking, are the elements satisfied for this crime?